Okay, hello, it's Pattyjo. I have been gone so long. I've been having a family emergency, so you don't want to hear about that. But just not a lot able to happen. So I'm trying to keep myself together. I don't know exactly where we left off. I think it's right where she's doing the sentencing, which I was thinking about doing live. I don't know how to. So if we want to repeat this on a live or repeat maybe some of our favorites on a live or something like that, totally willing to do it. I think we have topped 1,000 subs, which I am so happy about. Thank you and welcome. Okay, let's see where we did leave off. Why don't we try to get back into the swing of things? I'm sorry. And get going on this. Okay.
Thank you. Please be seated. Of course, I do need to first verify that they can hear and see us. I'm getting the thumbs up. We are back on the record. The record should reflect that Mr. Brooks is no longer in the main courtroom. He is in the adjoining courtroom. I, of course, have been erring on the side of constitutional caution, but I would note that his right to be present at sentencing is a statutory right, which, frankly, I probably don't need to go through the findings under Illinois versus Allen, but I did. But under whether it's a statutory right or a constitutional right, you can forfeit that right, and his behavior today has certainly demonstrated that he has forfeited his right to be present in this courtroom. During my sentencing remarks, he immediately came in. I was on the bench looking through my paperwork. The courtroom wasn't even open. And he started asking me questions. I said I wasn't going to answer them. He really had no respect for the proper decorum. I needed it to be on the record. He didn't seem to care about that. Wanted to debate me about my prior rulings. Bottom line is it's a statutory right for him to be present, and he's forfeited that right. And I would just add that it's part of a pattern that has been demonstrated during this trial, that when my perspective, things are not going in his direction, things are being said that he doesn't agree with, that he tends to act out, he disrupts, and I'll leave it at that. Once again, I'll confirm he can hear and see. We've got confirmation from the staff in the other courtroom. One of the reasons I really spent the time going through both my observations of Mr. Brooks in terms of the mental health related issues, and first, and then going through the victim impact statements before I go through all of the necessary factors for sentencing, is frankly it's challenging to talk about the impact to the victims without getting emotional. This trial is unlike anything that I've ever been a part of. The sheer magnitude of the crime, the number of people impacted, how they were impacted, the vicious, senseless nature of it, and hearing about the impact of all of that on our community members and the people who are at the parade, it's heart-wrenching. And I wanted to do that before I really got to the meat of sentencing. Because I also thought it was important to really spend some time recognizing and acknowledging the impact to the direct victims who are in this courtroom and who have provided statements. Today, my focus in sentencing will be about November 21 of 2021, the events shortly before that or leading up to it and after, and are not about Mr. Brooks's conduct during this trial, even though case law is very clear that his conduct at trial can and is a legitimate factor for the court to consider. I need to make the record very clear that in no way what I do here today is based on Mr. Brooks exercising his right to a trial. That is a firmly embedded constitutional right, which I support, which I upheld. Of course, every person charged with a crime has a right to a trial. This court honored that right. I protected that right, even if Mr. Brooks treated it with contempt, disrespect, and at times like a game. But sentencing today is directly related to his conduct on November 21 of 2021 and the other sentencing factors, which, as I indicated previously, include the seriousness of the offense, the need to protect the public, and his character and rehabilitative needs. Today, I am tasked with sentencing Darrell Brooks for 76 counts related to a couple of moments in time. Moments that are tragic, moments that were frankly avoidable. My sentence here today is, the purposes of it are twofold. Really threefold if we think about the community. One, it is punishment. Two, protection of the community. And three, what I hope is justice and closure for the families and the community at large. I, of course, want to recognize and give due respect to the guilty verdicts that were rendered by the jury in this case. Not just 76 guilty verdicts, but the special verdict questions that they answered, including for counts 1 through 6 and 7 through 67 that had the special verdict question related to the use of a dangerous weapon. So let me talk about the seriousness of this offense. The seriousness of the offense can be summed up, frankly, in one word, and that is attack. There is nothing, no other word that can best describe what happened on November 21 of 2021 than the word attack. I talked about during my remarks regarding the trial about the opportunities that Darrell Brooks had to avoid this altogether. I put Exhibit 15 on the screen for a bit, which is the exhibit that details the map. The map of the parade. It starts with White Rock. It shows where Sergeant Warner was at one point, farther up that parade route, the staging area, and I believe if you look further up on Exhibit 15, it even depicts where White Rock School is, and that, of course, is where we saw the video of the altercation between Mr. Brooks, Corey Runkle, Nicholas Kirby, and Erica Patterson. Now, of course, there were moments in time before that, but that is really where things started, where I believe Mr. Brooks boiled over with rage and anger that he chose not to control on this date. He had a number of opportunities to simply drive in the other direction down White Rock, but he chose to drive toward Main Street, even though from the testimony we know it was very evident that it was staging for a parade. There were many people, may not have been exactly by the school, but farther down White Rock. From Niagara forward is where that staging area was located, and many people were there. The sights and sounds of a parade, the signs on the side of the road telling people not to park there, for example. Instead of turning around, or instead of turning left onto East Main Street or left onto Pleasant, and despite Sergeant Warner trying to flag him down and being in front of a squad with lights and a clear indication you should listen to or honor the even gestures of a police officer, and he was in uniform, he drives down White Rock Avenue and has contact with Detective Casey, who very clearly did everything he could to stop Mr. Brooks. And in that moment, thinking it's a lost motorist. But Mr. Brooks chose to basically brush him aside with that SUV and drive on to Main Street, past more people, past many spectators, and in a manner that was not just at a speed inappropriate for a parade, but frankly, that was reckless and endangered anyone who was on the roadway at that time, whether or not he hit anyone between White Rock and Main and Barstow and Main. But during that 3-block section of Main Street, he could have turned off Buckley, Northeast Avenue, Martin Street, or in either direction on Barstow. He could have stopped, asked for the police barricades to have been removed, or frankly turned his car around even at that point and gone back the way that he had come. But he didn't do that. He chose to drive recklessly, carelessly, and maliciously through a parade route and at anyone in his path, where he struck not one, not two, not three, but 68 different people. We actually know that number's higher because we now know, we heard from the 2 individuals who were with Extreme Dance, the one girl who was struck by one of the individuals who was clearly struck, and that person flew into her. That would qualify for a charge based upon the state's description of how they chose to charge. It's just they didn't know until closer to the sentencing hearing. So 69 individuals if you include her. There are so many aggravating factors here, it's frankly difficult to even keep track of them all. The complete disregard for the lives of anyone else that day. Someone described it as depraved indifference, and I think that is the perfect phrase to capture the actions of Mr. Brooks on November 21st of 2021. The aggravated factors of the numerous opportunities to turn around or not even enter the parade route or simply to stop. The fact that he mowed over and used that vehicle as a battering ram to hit 68 individuals, never once stopping, with rage and anger at unsuspecting people at a parade who were there simply to kick off the holiday season, to experience joy with their families. The intentionality of the conduct is outstanding. The viciousness, the speed, the swerving from side to side at various points. This was not a case of whodunit. From the very beginning, from when this case was charged, it was clear who did this. Now, that is not to say that I prejudged this case. I did not. But after sitting through this trial, after watching the many videos, after listening to the testimony of the many, many dozens of witnesses, it is clear the state had overwhelming evidence of Mr. Brooks's guilt. What's also aggravated is his complete and utter lack of remorse. He spoke here today for 2 hours. One sentence, that's it. I'm sorry. No detail. 2 hours, one sentence. No empathy for any of these individuals. At times mocking them with hand gestures or rolling his eyes multiple times. That is not an indication or a sign of someone who has empathy, who is sorry for what he has done. We may never know the true why, but we were provided with nothing here today other than a feeble attempt to blame mental health, which frankly does a disservice to those who truly suffer from mental health issues. I understand why his family might cling to that because of the difficulty in coming to grips with a loved one doing such heinous things. But for Mr. Brooks, it's nothing more than indifference, deflection, and outright denial of what he did and the impact that he has caused as a result of his heinous actions. I searched for a mitigating factor in this case. I waited patiently for an apology, a true apology. I didn't get it. And not for my benefit, but for the victims. The law allows me to look at things such as Mr. Brooks's prior criminal history, including the history of criminal offenses and pending charges, the history of undesirable behavior patterns, which can include dismissed, uncharged, or unproven offenses or facts, even including expunged offenses not really relevant here, acts resulting in probation revocation. Of course, those are part of his criminal history, nothing specific to these charges. I can look at his personality, character, and social traits, the vicious or aggravated nature of the crimes, the degree of his culpability, his demeanor at trial and truthfulness, his age, his educational background and employment record, his remorse, repentance, and cooperativeness, his need for close rehabilitative control, the rights of the public, the recommendations of the interested parties, including victims and family members of homicide victims. I can consider statements made by his own family. I can certainly consider the length of pretrial detention, which I'd note, though, when facing 6 life sentences, is really a fraction of the time available to this court. The loss of life in this case is certainly one of the aggravating factors here today. The number of people injured, also an aggravating factor. The reach into the community, certainly palpable because this was a Christmas parade. I think it was a comment earlier, either today or yesterday, that this was not like one act where Mr. Brooks drove into a crowd of people. This was sustained driving from block to block to block to block, picking off people that were unsuspecting. 68, 69 times. Driving over people as if they were nothing more than speed bumps. What's also aggravated is his conduct after he drove through the parade. Crashing his vehicle in an attempt to flee. It's pretty evident based upon the evidence and testimony from trial that Mr. Brooks had no idea there were these logs in that backyard that could damage his vehicle. He was attempting to flee when he ran over them, and it ultimately disabled that vehicle, and he was forced to abandon it. He ditched it, leaving personal identification information in it and his phone in a clear attempt to get out of there in a hurry. And then we have that series of videos that we saw at trial of him going through backyards, coming in contact with people, asking to use phones, ultimately ending up at Mr. Ryder's home, who graciously took him in. Never once Mr. Brooks showing any signs of distress, of any emotion of what he had just done. Cool, calm, collected. Certainly not a sign of someone who had any remorse for what he had just done. Someone who's involved in an accident, even a tragic accident, one where they flee the scene and are later caught, oftentimes show incredible remorse, tears. Not tears for themselves, but tears for what they've caused. A recognition of the loss of life, for example, from their conduct. Nothing. An individual who simply wanted to flee. That is the epitome of consciousness of guilt evidence. Fleeing, changing your appearance, taking off the sweatshirt, not even caring that your shoes are off your feet because you're so intent on fleeing the area. Putting your hair up from it being down. No doubt, this is by far and away one of the most aggravated cases I've ever presided over. The sheer magnitude of the loss, the number of victims, the types of crimes for which the jury has convicted him. 6 counts of intentional homicide, 61 counts of first-degree recklessly endangering safety, 6 counts of hit and run, 2 counts of felony bail jumping.
What does that say? What does that say? Standing there with his dumb little sign, like a little kid. Ugh.
1 count of misdemeanor battery. What's further aggravated is the fact that he was out on bond. He should have had no contact with Erica Patterson. But the rules mean nothing to Mr. Brooks. Nothing. He didn't care. This was someone who on two prior occasions charged with, frankly, causing mayhem. One, a reckless endangering safety for discharging a firearm. The other for battering and then running over Erica Patterson's foot. This court does get to consider the other act's evidence that the state sought to introduce at trial. That other act's evidence includes that on November 2 of 2021, Milwaukee police took a complaint from Erica Patterson that Mr. Brooks had run over her with his vehicle and tried to kill her. She had tire marks on her right pant leg. She could not move her leg and had blood coming from her mouth. On that date, Mr. Brooks was driving the same vehicle that he drove through the parade. Erica Patterson was conveyed to Frederick Memorial Hospital. Her injuries received medical attention. She even had that boot on her leg on November 21 of 2021. She described Mr. Brooks to police as yelling at her, using profanity, as she tried walking past him when she was at a gas station. I think initially before that, at another location, but ultimately where he allegedly ran over her was at a gas station and caused the injury to her leg. Struck her in the face once with a closed fist, causing pain and bleeding without her consent. And then it was after she walked away that he followed her. When police had contact with him.
This reminds me of that one line in Kindergarten Cop. You know that movie with Arnold Schwarzenegger, I think, when they say the lady officer bends down when he's the kindergarten teacher and the lady officer is something else, and she bends down and says, "You're not so tough without your car, are you?" I'm aging myself.
He denied driving his mother's vehicle.
Yep. Tantia.
When police had contact with him at his house, he ignored their commands because he was found in the vehicle, claiming that he was having an anxiety attack upon the sight of the squad car and needed to get into the home to get his inhaler.
My inhaler. That was made up.
When I say the rules don't matter to Mr. Brooks and court orders mean nothing, Mr. Brooks was in custody, and there are jail phone calls where he's berating Erica Patterson, encouraging her to recant, blaming her for what had happened.
For running over her.
Saying things on that phone call like, "You trying to make it seem like everything is always everyone else's fault but yours. Like you don't never do anything to cause shit. And the whole cause of this shit was something that you fucking did." He ended the call by telling Erica Patterson, "You did this shit, and you couldn't even keep your mouth shut after numerous people told you that shit. This ain't the place for you to be doing this shit, and you still ran your mouth. And I'm the one sitting in here facing all this time." Repeatedly calls her a bitch. During a phone call on November 11th, Darrell Brooks is overheard or captured saying, "Why in the hell would I just try to mow her down knowing I could kill her like that? Like, okay, I probably got a few screws loose, but I ain't hardly no goddamn fool."
Huh. Prove it.
He's complaining that she won't help post his bail. "You didn't put a cent on my bail. Why should someone else have to pay for some shit you caused?"
Gaslight much?
The end, apparently, of that conversation, or at least moments later, he says to her, "Nah, I didn't try to do anything, because if I tried to do something, you wouldn't be on the phone now. That's what you're not realizing. If I really tried to do something, you wouldn't be on the phone now." That is the rage and the anger that Mr. Brooks had on November 21 of 2021 when he tracked down Erica Patterson, confronted her. This wasn't about him getting money from her, like he lied to Detective Carpenter about. This was to confront her. He clearly hit her, we know that. This is the type of man that drove through the Christmas parade, enraged because, frankly, it's entirely possible that Corey Runkle and Nicholas Kirby saved the life of Erica Patterson. It's clear Mr. Brooks was hell-bent to cause harm to her, but she was able to get free, run back to her friends. Who knows what would have happened but for their intervention. If you think back to the testimony of Nicholas Kirby, he felt bad for threatening Mr. Brooks, like somehow this was his fault. He was just trying to be there for his friend, someone he recently met. So, Mr. Brooks, that other act's evidence is a very clear indication of your poor moral character. It demonstrates unequivocally that you have absolutely no remorse for anything that you do. You have no empathy for anyone, and that you are justified in the actions that you take. In addition to that conduct, as part of your character, this court is able to look at and consider your prior record. And I'm well aware, sir, that you're raising an objection sign, but you have forfeited your right to be here, and I will not stop, and you will not be brought into this courtroom. I will continue. This is his prior record, going back to two thousand, spanning what? Nevada, Georgia, at least police contact in Georgia. We have an unknown disposition, and Wisconsin. Substantial battery in 2000, party to a crime. Put on probation, ultimately that was revoked, he went to prison. 2002, felony possession of THC, jail time. 2003, resisting obstructing, jail time. 2005, a disorderly conduct ticket, but he failed to pay the forfeiture and ended up serving an alternative to incarceration. Sorry, he ended up serving for failing to pay 30 days jail. 2009, obstructing, 2 days jail, meaning he lied to police. 2010, strangulation. Battery was dismissed and read in, put on probation, ultimately revoked, serving 11 months jail. 2012, misdemeanor bail jumping, possession of THC, with a number of other charges being dismissed and read in, 180 days jail concurrent. Also in 2012, a misdemeanor resisting or obstructing. So either he lied or he fled from police or did something to make their job more difficult. 37 days jail consecutive. In Nevada in 2006, domestic battery, a suspended sentence. Obstructing after being found guilty at trial, for which he served jail time. 2007, statutory sexual seduction as a felony. This is for impregnating Erica Patterson when she was a minor. 2016, charged with not being in compliance with the sex offender registry requirements, for which there is an outstanding warrant. In Georgia, a 2021 arrest for battery, domestic violence, presumably with Erica Patterson based upon where she came from at that time. But I won't make, I say presumably, but frankly doesn't matter who it was with. We also know that there's the 2003 paternity case out of Waukesha County. Why is that relevant? Because 8 times during that case, a warrant has been issued for contempt of court, meaning for failure to pay his financial obligations to a child or children. The pending cases for which one pending case, I should say, he was, I don't believe, charged with bail jumping for that one. The 20 CF 2550, 2 counts of recklessly using a weapon, felon in possession of a firearm, released ultimately in March of 2021. He's accused in that case of firing a shot. There were two occupants in a vehicle. One was his nephew, and when he was picked up by police, a loaded Beretta, 9mm, which had previously been reported as stolen, was found in his possession. Ugh. I already talked about the other acts evidence. That is the for which he was charged with felony bail jumping, the second-degree recklessly endangering safety for allegedly running over Erica Patterson, the battery DV, DCDV, and a resisting obstructing. And then the second would be he was charged with intimidation of a victim, felony bail jumping for conduct on November 8th. So November 2nd, November 8th. This is clearly someone with a demonstrated violent history and past, someone who has absolutely no regard for anyone but himself. To say that he is a lifelong criminal, I think, is accurate. He disobeys law enforcement, he disrespects court orders, and he certainly demonstrated that he has no respect for these proceedings. Multiple acts of violence, violent, dangerous behavior that predated the attack on the WAUKESHA Christmas parade. His character, or lack thereof, is also demonstrated by his complete and utter denial of culpability in this case. His blaming of his mental health or alleged mental health. There's no evidence that he was suffering from a manic episode. I went through all of that earlier today, going through the 4 reports related to the special plea. None of those doctors found support for his special plea. Mr. Brooks talked about, at times, this being the will of God, or that all things happen for a reason. I'm here to tell you, Mr. Brooks, you are not an instrumentality of God. Death may be inevitable to all of us, but you cut the lives of 6 individuals short. You alone, Mr. Brooks, cut the lives of these 6 innocent people short. I talked earlier about how I believe he's intelligent, deliberate, and purposeful in what he does. I've considered that you have treatment needs. Perhaps there are intersecting mental health issues as it relates to your personality disorder, but those issues can best be addressed in a confined setting where the Department of Corrections will be charged statutorily to evaluate you and to provide any medical or mental health treatment that you need. This is a case that falls squarely on the need to protect the community. I referenced this earlier. There's really three primary reasons for the sentences I will impose here today. One is punishment, one is to protect the community, and the other is to provide justice and closure to the victims. Because under that category of need to protect, the court does get to consider the impact of these crimes on the victims. I went through at length in reviewing all of those victim impact statements. I certainly didn't go through every single one, just highlighting some of them, but doing so with purpose, because it is very clear to this court that Mr. Brooks has caused carnage, mayhem. It has resulted in many people suffering from PTSD, from mental and emotional trauma that will take a lifetime to recover from, and for some, perhaps, if at all. You have taken away from these individuals future memories. They will never have birthdays with the 6 individuals who were killed. There will be no weddings. There will be no graduations. There will be none of the milestones that these families were looking forward to, whether it be for an innocent 8-year-old or an innocent 79-year-old. Frankly, Mr. Brooks, no one is safe from you. This community can only be safe if you are behind bars for the rest of your life.
Throw away the key.
The actions of Darryl Brooks demand punishment. The community is not safe from your violent and criminal conduct unless you are in custody. You left a path of destruction, chaos, death, injury, confusion, and panic as you drove 7 or so blocks through the Christmas parade, never once stopping or seemingly caring about the wake of carnage that you left. 4 of those blocks were turned into a scene that frankly is no different than a war zone. On counts 1 through 6,
Yes, here we go.
this court is imposing a life sentence without the possibility or eligibility for extended supervision consecutive to one another. 1 life sentence for Virginia Sorensen. 1 life sentence for Leanna Owen. 1 life sentence for Tamara Durand. 1 life sentence for Jane Kulik. 1 life sentence for Bill Hospel. And 1 life sentence for Jackson Sparks. I've considered the enhancer and the additional 5 years that I could impose, but I don't need to really order that because I've not made him eligible for extended supervision, and it would only be to increase his time on initial confinement. But make no mistake, Mr. Brooks, you use that vehicle as a battering ram, no different than, frankly, a firearm. On counts 7 through 67, these are 61 counts of first-degree recklessly endangering safety. These charges alone and these convictions without the enhancer carry a maximum of 12.5 years. Because of the enhancer, a total of 17.5 years. And under Wisconsin law, the 5 years is added to the initial term of confinement. So what could be 7.5 years is a maximum of 12.5 years. And I'd ask that everyone no longer show any reaction to the sentence so I can get through this. On counts 7 through 67, on each count, I will impose a total sentence of 17.5 years. Wow. 12.5 years of initial confinement, plus 5 years of extended supervision, consecutive to any other sentence that I've imposed here today. That is 762.5 years of initial confinement and 305 years of extended supervision.
Wow.
On top of the life sentences that I've imposed. That is 17.5 years, sir, for Nicole White. 17.5 years for Eleanor Anders, 17.5 years for Sasha Catalan Castillo. 17.5 years for Maura Gilchrist. 17.5 years for Justin Gullickson. 17.5 years for Harry Guilfoy. 17.5 years for Aidan Lofgren. 17.5 years for Theo Maza. 17.5 years for Tyler Hudliner. 17.5 years for Connor Tank. 17.5 years for Eric Teagues. 17.5 years for Adelia Maffioli. 17.5 years for Kelly Graybow. 17.5 years for Josh Craner. 17.5 years for Riley Rogers. 17.5 years for Caden Rogers. 17.5 years for Tucker Sparks. 17.5 years for Isabella Bartlett. 17.5 years for Yaritzi Becerra Montez. 17.5 years for Samantha Coelho. 17.5 years for Madison Hollingsworth. 17.5 years for Mackenzie Hollingsworth. 17.5 years for Mitchell Lampine. 17.5 years for Kathleen Pielmeyer. 17.5 years for Julia Schleichow. 17.5 years for Olivia Stover. 17.5 years for Jennifer Stover. 17.5 years for Jesselyn Torres. 17.5 years for Alice Urell. 17.5 years for Charlotte Urell. 17.5 years for Vivian Urell. 17.5 years for Grayson Urell. 17.5 years for Lola Hospital. 17.5 years for Tamara Rosentreter. 17.5 years for Betty Strang. 17.5 years for Maria Alvarez Dominguez. 17.5 years for Gregoria Romelia Perez. 17.5 years for Elliot Hallmark. 17.5 years for Benjamin Hallmark. 17.5 years for Patrick Heppy. 17.5 years for Lori Locken. 17.5 years for Marisol Lopez Gutierrez. 17.5 years for Adair Lopez Rubelar. 17.5 years for Juan Marquez. 17 and a half years for David Marquez. 17 and a half years for William Mitchell. 17 and a half years for Jason Petchloff. 17 and a half years for Margaret Pachulis. 17 and a half years for Yamilet Perales Alvarez. 17 and a half years for Aylan Perales Alvarez. 17 and a half years for Ashley Perales Alvarez. 17 and a half years for Jose Perales Alvarez. 17 and a half years for Maria Perez. 17 and a half years for Camila Perez Gonzalez. 17 and a half years for Isaac Foglia. 17 and a half years for Deborah Ramirez. 17 and a half years for Charles Green. 17 and a half years for Lily Green. 17 and a half years for Brinley Harris. 17 and a half years for Kelsey Knapp. 17 and a half years for Owen Ricciati. On counts 68 through 73, which are the 6 counts of hit and run resulting in death, these are 25-year felonies each. The court will do the following. On count 68, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision. This will be concurrent to count 1. Count 69, the same sentence, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 2. Did I say that the right way, the first one? Okay. Count 68 is concurrent to count 1. Count 69 is concurrent to count 2. Count 70, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 3. Count 71, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 4. Count 72, 25-year total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 5. And on count 73, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 6. On count 74 and 75, the 2 felony counts of bail jumping, the court is ordering a 6-year sentence total on each count, 3 years of initial confinement, 3 years of extended supervision, consecutive to all other counts but concurrent with one another. And lastly, but certainly not least, the maximum sentence for the battery to Erica Patterson, 9 months consecutive to any other sentence. To order anything other than what I have done, sir, would be to unduly depreciate the seriousness of these offenses. It is needed, although largely symbolic, given the number of years that I have imposed here today, because frankly, you deserve it. I know it's symbolic, but it needs to hold you accountable in a very real and tangible way. For all of these sentences that I have imposed, I will order the following conditions: no contact with the victims as identified in the amended victim key or their families, no contact of any kind with Erica Patterson. You are to pay restitution in the amount of $47,193.29 to EMC Insurance Company, that's on behalf of the Waukesha School District, and $124,000, $220.65 to the Crime Victim Compensation Program. I am ordering DNA surcharges on all counts. On counts 1 through 75, it's $250. On count 76, it's $200. Those are mandatory under the law. I'm also imposing the domestic abuse surcharge on count 76 of $100. I'm also imposing all standard court costs on all counts. Although my primary emphasis is that restitution be paid before costs, surcharges, and fees, I will order that restitution, costs, and fees be paid out of prison money, and In other words, that all financial obligations shall be collected pursuant to statutory provisions as requested by the state. That's frankly a standard, it's customary, but it will be in the judgment of conviction. And then pursuant to 949.165, I'll find that it is appropriate for this court to order an escrow account under 949.165 for payment of restitution, costs, fees, surcharges, and even for costs associated with prior legal representation or future representation under the statute. Mr. Brooks has been convicted of a number of serious crimes for which this section is appropriate. I will order 360 days credit as to count 1 and count 68. Only, all other counts, 0 days credit because of the consecutive nature of the sentences that I've imposed here today. I calculated that with my sentence calculator. Of course, that is through yesterday because these sentences commence today. There are a number of advisements I must go through. First of all, Mr. Brooks will be provided with a written explanation of determinate life sentence regarding the first-degree intentional homicide charges. Of course, he's not eligible for release to extended supervision. That form defines extended confinement for him, and there's other language on here that he can read at his convenience. He also will be provided with the Notice of Right to Seek Post-Conviction Relief form. The court will fill out the caption for him. He is instructed to review it and review the defendant's acknowledgement, make the appropriate selection, sign and date it, and return that to the court. I must advise you, sir, you have been convicted of a felony. That means you may not vote in any election until your civil rights are restored. You may not possess a firearm. You may not possess body armor. Both of those are punishable as felonies. You also have 20 days from today's date to appeal the decision of this court. Does the state believe I've overlooked anything here today?
No, thank you, Your Honor.
All right, those documents will be provided to Mr. Brooks. I will note for the record, at many times during my final sentencing remarks, he was holding up an objection sign. That objection is noted for the record. This now concludes this hearing and this case. We are now off the record.
Do you want to do the motion stay pending appeal, or we could do it another day?
I want to wait till I sign the judgment of conviction.
Okay.
I'm not making any determinations regarding where he is to be held. That certainly is within the, once the judgment of conviction is signed, I'll address the motion for stay pending appeal. But my understanding is he needs to be transported to Milwaukee, and I will not stand in the way of that. All right, I'll schedule that once the judgment of conviction is signed.
Understood.
We are in
Thank
recess.
you.
Thank you, everyone.
Thank you.
Okay. Just such a little guy. Okay, that's it. All right. Thank you so much for joining me through all of this. I say we do something live and go back to maybe some highlights or something, or maybe onto something new or something like that. You guys tell me. I'm going to try to catch up. There's about 500 comments that I'm behind on, and it's because of this emergency that my family is going through. It's not me directly, but it does impact me as collateral damage. And it does have something to do with a narcissist, quite frankly, and trying to get a family member away from that narcissist. So, or actually a couple of them. So I'm going to be, just really struggling through that, emotionally, mentally, financially, all of those things, because that's how it goes. But here, I finally learned how to, I don't know how that looks. I'm sure it doesn't look like the package, but I'm kind of proud of it. Okay. All right. Well, I hope everybody here is doing something new. I'm going to go work on my motorcycle today and maybe even take a ride. It's really nice out. I will see everyone next time. I am looking again through the Adnan Saeed Heyman Lee murder case. It was something local to this area and spanned over 20 years. Of course, everybody knows about the Serial podcast, I think, and the other podcasts and the HBO special and things like that. I think I might start with, actually, he did a press conference about a year ago, and my opinion of that has evolved so much. So that might be one that is interesting to me. But thank you everybody. Thank you so much. And for the ones who sent personal emails, thank you. Anybody who has sent money, which not very many people do, it's fine. I have contributed also to WAUKESHA because I think that's just right. I'm not trying to make money. This is a hobby. This is something for me to do. I really appreciate everybody. Thank you so much. And this is Patty Jo. I'll see you next time. Okay, let's see if I can figure out how to do this. It's going to take a minute. You know me. Bye.